All right, Eli Rico.
Yes, Your
Is your
Honor.
client, Mr. Jose Hernandez, ready?
Yes.
Yes,
All
Your
right.
Honor.
Is your screen working? Is everything working now?
Yes, sorry about that.
No problem. Is there a prosecutor available?
Sure, Ray, Judge.
All right. Court is calling 2021 CR 0478, State of Texas versus Jose Hernandez. Can I have parties announced for the record, please, for the state,
Sure, Ray Garcia.
for the defense?
Eli Rico.
And are you Jose Hernandez?
I am.
We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Hernandez, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Next, counsel, I'm going to show you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case? And did you review that discovery with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hernandez, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
What you're charged with is repeated violation of court order or bond conditions, family violence. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
I'm sorry, Your Honor, I didn't hear you, Your Honor.
Has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He has, Your Honor.
Do you believe your client is currently confident and was sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review that page with your attorney? Did you
Yes.
understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There is a $1,500 fine. State recommends community supervision. State will take in consideration county court cause numbers 536-349, 620-533, and 620-770. And there's to be no contact with Justin Westmoreland. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm going to show you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been signed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is recommending that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 120 hours community service restitution, random UAs, and the MILF evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all its attachments.
Any objections?
No objections, Your Honor.
Mr. Hernandez, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand today that the state will be presenting evidence in the form of witnesses and statements, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, everyone, just give me a moment, please. All right, could I see the state and defense in the breakout room, please?
Yes,
If
Your Honor.
y'all could meet me in breakout room number 1. All right, Jose Carlos Hernandez, where are you? All right, if you can unmute, please.
Can you hear me?
Yes, I can.
Okay.
Brenna, I dare say it's working. Why it's working now, I don't know. All right, we're back on the record. The court has reviewed state's exhibits 1 and attachments, and the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor, we are.
All right, is there anything you wish to say on behalf of your client?
Just, Your Honors, we would ask the court to follow the plea agreement.
All right, so Mr. Hernandez, what is your issue?
When I was younger, I made some choices, and choices were mistakes.
Well, I mean, these dates are from 2020. I mean, we're in 2021. So it hasn't been that long ago. How old are you?
I'm 26, Your Honor.
Okay. So you're not like a 16-year-old, not that that would excuse it either. So again, this person doesn't want to be with you. Do you understand?
I understand.
I mean, sometimes relationships work out, sometimes they don't. When they don't, you got to move on.
Yeah, sure.
Do you understand?
Yes, I do.
So you and this person, you don't have a home together, don't have children together. Am I correct?
That's correct.
So move on. Am I going to have any trouble with you trying to contact this person?
No, Your Honor.
All right. Are you employed?
I am.
What do you do?
I'm an office manager for a dental office.
All right. Do you have any children?
I don't.
What are you doing in your spare time?
I work out, hang out with my dog.
All right. This is, excuse me, state, have you contacted the complainant? Are they aware of this offer?
Yes, Judge, and afterward, there's a short victim impact statement that the complainant requests the state read.
All right. All right, the court will sentence you to 4 years in the prison, suspended and probated for 4 years, $1,500 fine that will be probated. Court will take in consideration County Court Cause number 536349, 620533, 620770. There's to be no contact with Justin Westmoreland. And just in case my accent is butchering that last name, it's Westmoreland. 120 hours of community service restitution. 40 hours will be waived if you obtain the COVID vaccine. And I want the record to be clear. I'm not requiring you to get the COVID vaccine. You don't have to get it if you don't want to get it. That's completely up to you. But if you complete the entire protocol for whatever vaccine you choose to get, be it the 1 shot or the 2 shot, I'll deduct 40 hours from your community service restitution. If you're drug tested, excuse me, Mr. Hernandez, could you unmute? If you're drug tested today, what are the results going to be? You need to unmute.
Sorry.
Yes.
Light marijuana use.
And what else?
That's it.
All right. There's no steroid use or anything like that, is it?
No.
Okay. I'm going to want UAs test him for levels, and those levels need to start going down, Mr. Hernandez.
Yes, sir.
There'll be a MIC evaluation. Is there any past mental health issues? Is that why we're asking for a MIC evaluation, or it's just because he didn't understand when the relationship is over? What is the reason for that? Mr. Hernandez, do you have any mental health issues?
No, Your Honor.
Ever been diagnosed?
No.
Okay, well, I'm assuming they want the mental health evaluation because you could not end a relationship the way relationships should be ended, which is Sorry it didn't work out. Thank you very much. Nice experience, and go on about your business. So I'll do a MIC evaluation. There'll be regular Zoom reporting. If you can't report by Zoom because there's something wrong with your equipment, then you'll need to do it in person. Proof of employment within 30 days. No employment as a home health care provider or supervision of minors. Rebecca, is there anything else that he needs?
No, ma'am.
Anything else that you need from me, Mr. Hernandez, in order to be successful on this probation?
No, Your Honor, but I did want to let you know that I've already been vaccinated.
All right, then you can give that proof to the probation and the other duck 40 hours. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Hernandez, this is how relationships work. When it's over, it's over. You understand?
Yes, Your Honor.
I always tell people, if you want to be in a relationship, to know if you're ready for that relationship or not, get an orchid. If that orchid blooms and is healthy for a year, you're ready for a relationship. Because that orchid, in order to bloom, it's going to require patience. It's going to frustrate you because you're going to say, I'm doing everything that direction's saying, it's still not blooming. But if you keep it alive for a year and it actually blooms, you may be ready for a relationship. So right now, whether you're in a relationship or not is completely up to you. But I'm saying you're probably not ready for a relationship yet. You understand?
I understand.
And don't smother your animal with a lot of time, because sometimes they want to be alone. And they're like, why is this guy, Jose Hernandez, around me all the time? Can I get some peace by myself? Sometimes they want some peace and quiet. They want to be left alone. Just throwing that out there.
I understand.
All right. So I'm going to send you to breakout room number 1, Mr. Hernandez. I need you to be patient in that breakout room because I have another case to take up that probation needs to remain in here to hear this. So Mr. Rico, if you would do me a favor and pull out some more patience with out of your pocket, if you will be with Mr. Hernandez in breakout room number 1 until probation arrives, I would appreciate it.
That's fine, Your Honor. Thank you.
All
Your Honor.
right. You're welcome. And you can go back to 1, Mr. Rico. Who are the
Thank you,
parties on Ricky Ray Esparza? Ricky Ray Esparza.
Yes, ma'am.
Who are the parties? Ah, there we are.
No. Just leave it alone.
Hunter, is this your case or is it Marcus?
Marcus.
Okay. If I remove the spotlight people, it won't work anymore.
Happy to be here, Judge.
Okay. All right, the court is calling 2021 CR 5889, State of Texas versus Ricky Ray Esparza. Could I have parties announced for the record for the state?
Marcus Sanderson.
For the defense?
Nestle Sahanovich for Mr. Esparza.
And are you Mr. Esparza?
Yes, ma'am.
We're proceeding by video because of the pandemic. I'll note for the record that Mr. Esparza and his attorney are in the courtroom. The reason for Mr. Esparza being in the courtroom is because his Zoom was not working. Any objections to this taking place by video, state?
No, Judge.
No objection.
Defense? Mr. Esparza, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Esparza, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Oh, I am so sorry. Just out the record for a moment. Joe Ray,
Yes, Judge.
I'm so sorry. You wanted to read a letter. Is that correct?
Yeah, it's very, very short. He just
All
wanted.
right. What I'll do is I'll bring him out of the breakout room after I finish this plea, and I'll allow it to happen. I'm sorry, I forgot about that.
That's all right. Thanks.
Sure. All right, Mr. Esparza, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is driving while intoxicated, third or more? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Esparza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,000 fine. There's no application for deferred adjudication. The state recommends community supervision. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
Your Honor, I think there was an application for deferred adjudication.
No, there's not. The court is only in receipt of an application for community supervision, not for deferred adjudication. And the
Okay.
plea bargain says no application. So is that not the plea agreement? Is there supposed to be an application for deferred adjudication?
I thought there was, Marcus.
Well, I tell you what, I'll send you and Mr. Sanders in a breakout room and you can discuss it. I'll send you to breakout room number 2. So courtroom, if you could go to number 2, please.
Yes, Judge.
And Robert, could you go to number 1 and have Mr. Jose Carlos Hernandez come out of the breakout room and also his attorney? Thank you. And Joe Ray, are you there?
Yes, I'm here.
Oh, could you start your video, please?
Can you see me?
Yes, I have you now.
Okay, Your Honor, I'm back.
Hi, thank you. I forgot. There is a victim impact letter that is to be read. Mr. Jose Carlos Hernandez, this is not on the record. It's a letter that the complainant wanted read. So I always tell people, treat everybody with respect. So just internalize what's being said, okay? All right, Joe Ray, you can begin.
Thanks, Judge. It's just a short statement. It states following. Hope you get the help that you need. Please follow the rules of probation. Please do not contact me and make better choices. God bless. That's all I wanted to say.
All right. So that is the end of that. And then Rebecca, you can go to a breakout room to go over conditions. I'll send you everyone to breakout room number 3.
Okay, thank you, Your
And
Honor.
then thank you so much. So Mr. Hernandez, if you'll go to breakout room number 3, please. And then Brenda, we will stay on this spotlight because otherwise we will lose the spotlight and take care of the rest.
Because I'm not using this. I'm not using that camera.
All right, in the courtroom, is the attorney there for Mr. Flores?
Yes, Your Honor, I'm here.
All right, are you ready to proceed on that?
We are, Judge.
All right, who is this, who's the state on Flores? Okay. All right, the court is calling 2021 CR 1306, State of Texas versus Eleazar Flores. Can I have parties announced for the record for the state,
Nisbet.
for the defense?
Sergio Ibarra for Mr. Eleazar Flores.
And are you Mr. Flores?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
None.
Any objection from the defense?
No, Your Honor.
And the court will note for the record that the defendant and defense attorney are in the courtroom and that a plea was taken in this case on July 16th by video. On July 16th, 2021, the defendant entered a plea of guilty. There are no applications. According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. Is there anything from either side? For counsel for the defendant, anything you wish to say on behalf of your client?
No, Your Honor, except we asked the court follow the agreement here, entered into in good faith. Mr. Flores has expressed since the very beginning his remorse in this matter and the desire to take responsibility for this and do what he must.
All right. The court will follow your plea bargain agreement, sentence you to 5 years in the prison. Taking consideration 2021 CR 1307, give you credit for any time served. There's an affirmative finding of deadly weapon, which was a part of the plea bargain agreement. Is there anything else from either side with regards to sentencing?
Sentencing from the state, no, Judge. We just have 2 victim impact statements.
Mr. Flores, I'm going to show you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, then with that, we will close the record. My understanding there's going to be victim impact statements, Mr. Flores. I require that everyone treat everyone with respect. So just internalize what's being said. Do you understand? All right, state.
Yes, Your Honor. Joe, Mr. Pendon, if you want to unmute, you can go ahead.
Thank you. This is from Maddie's grandmother. What you did to Maddie hurts us so much, and I know I will carry this pain with me for the rest of my life. But I want you to know that I am praying for you to please ask God for forgiveness and reform your life. For Maddie's and your sake, please repent by living according to God's commands. God bless you.
Mhm.
And for me, I have a few more comments.
Yes.
Words cannot adequately portray the sadness, confusion, anger, and pain we feel at the loss of our precious Madeline May Pendon. Her life ended tragically and senselessly because of the careless and negligent acts of Mr. Eleazar Flores. Maddie's extended family and friends share in the grief and bewilderment his cavalier and irresponsible actions have caused. Mr. Flores ended Maddie's life and took her away from us, and it was totally unnecessary. He took away her future, and he took away our future with her. She won't be with us again on this earth, and her absence is felt daily by those who loved her. It's been hard for us all. Maddie's death has had a profound effect upon us, her family, and friends. We miss her smile, her enthusiasm, and her inspiring courage. We miss her love of art and dance, as well as her warmth and kindness toward others, especially little ones. We miss her impish, fun-loving, and artistic nature. Her life was ended way too soon, and we grieve as we move our lives forward without her. Our lives are forever changed. Maddie's brother Samuel has been deeply affected. Maddie was Sam's best friend and companion. She was 2 years older, and she was a constant presence in his life. They went everywhere together. They shared school vacations and even trips back and forth between mom's house and dad's house. They rode back and forth to school every day together. They went snowboarding and scuba diving together. They hung out with cousins, aunts, uncles, and grandparents together. She was his steadfast colleague throughout the first 15 years of his life. She looked out for him and gave him advice as any big sister would. She checked on him often at school. Maddie loved taking care of younger kids, and Samuel was the first to benefit from her maternal instincts. She was there every day until she was suddenly gone from his life. Sam has suffered from depression and nightmares since Maddie's passing. He's on medication for anxiety, depression, and nightmares, and sees a therapist for grief counseling. His schoolwork has suffered, and he has had difficulty concentrating and sleeping. He has been hospitalized and undergone many hours of therapy. He has come a long way with the help of mental health professionals, but he still grieves the loss of his sister. Samuel no longer has his best friend. As Maddie's father, I have also struggled with losing her. It's a deep and profound sadness that only a parent who has lost a child can know. I have felt overwhelming sorrow and emptiness due to her absence. I've had to deal with the fact she is no longer here. No more birthdays to celebrate, no high school graduation, no going off to college, no getting married, and no family or children of her own. These milestones and celebrations with her were all taken from us. I also miss the joy of just talking and spending time together. I haven't slept well since her death. My wife says I toss and turn at night, and I often call out in my sleep. I've suffered from sadness and anxiety. I've sought the help of a counselor as well as leaned on friends and family to deal with my grief. Every day I spend a little time working on my grief, and I try and help my son process his grief as well. The upheaval created by this situation has caused stress on my marriage and family. Coping with the loss of Maddie has been a struggle for us all. No parent should ever have to bury their child for someone else's carelessness. We, family and friends, are all saddened beyond words. We've all been affected by this tragedy. Mr. Flores, putting you in jail will not bring Maddie back. It will give you time to reflect how your carelessness and negligent actions have affected the lives of others. First, you were irresponsible by bringing a gun with you on the day of the incident. Second, you did not know how to handle the gun in your possession. Third, you ran from the scene like a coward and did not render aid. Finally, you failed to own up to your actions and you ran from the police. In short, your irresponsible actions resulted in Maddie's death, and you did not show remorse or take responsibility. You have injured the rest of us irreparably. You have taken the most precious thing you could away from us. I hope you spend the time ahead of you to reflect on your actions and figure out how to turn your life around. I charge you with figuring out a way to honor Maddie's life. You get to keep your life, and she lost hers. You need to figure out how to pay tribute to the life you've taken. It's the least you can do. Thank you, Your Honor.
Thank you. Is there another?
Yes, Judge. Rebecca, are you on here?
Yes.
Okay.
I'm Rebecca Wilson, Maddie's mother. This is written specifically to Laser. I'm grateful that I had the opportunity to speak with you a month or so ago. It helped in my healing process to know exactly what happened that night, and I did see remorse in your eyes when we spoke. With that said, here are some of the things that I will miss about my beautiful daughter. Maddie had this infectious laugh and beautiful smile with her dimples. She had an especially playful and goofy side that she shared with her brother, Sam, and myself at home. I will miss watching my daughter dance and sing. Maddie was an amazing dancer, and her eyes were full of light and expression when she would sing. I will miss how Maddie was so headstrong and determined. When she decided on what she wanted, whether it be somewhere she wanted to go, a project, or with whom she wanted to spend time with, she put everything in it. I have heard that when you lose a parent, you lose your history, and that when you lose your spouse, you lose your present time. But when you lose your child, you lose your future. I agree with this. I have lost my future with Maddie May, her high school graduation, taking her to college, moving her into a dorm, sharing in her life experiences, learning of her relationships, seeing her in love, graduation from college, being able to shop for wedding dresses with her, her wedding, pregnancy, and birth of our grandchildren. All of those joys, successes, heartbreaks, losses, all of the moments shared with my daughter. I have all the stages in our growing relationship as mother and daughter, as she would have developed into adulthood. My life and my son's life and all of our family has been changed forever. I'm not the same person that I used to be. In many ways, my light went out that day. I will miss that every time I would say goodbye to Maddie, either in person or on the phone, she would say, "I love you, Mom." I will miss her warm hugs and giving nature. She always strived to help others. Also, on behalf of my son, Samuel, I would like to share his losses. Maddie was his only sibling, and she always had his back. She was there to help him, teach him, and to protect him. They were each other's constant in our broken family, always together in heart and spirit. Samuel is now an only child. He has lost his support system, his best friend, and the one person that was to always be there for him past losing his mom and dad. Additionally, Maddie's tragic death severely impacted our already high conflict custody case, as I was blamed for her death. As a result of your grave irresponsibility, my son and I had to endure 381 days of separation, and even now are only allowed very little contact. Maddie would never have let this happen because she would have had Sam's back, and she would have protected him in ways that I could not in courts. Samuel lost his sister and his mother as a result of this, and I essentially lost both of my children. My heart was broken entirely in an instance by your carelessness for the life of another, someone who had been a friend to you and tried to help you. Maddie and I shared a very special connection that only mothers and daughters share. I felt her spirit leave her that night as I was driving towards University Hospital, desperately trying to find which hospital she had been taken to by ambulance. The words just came out, "Maddie, don't leave us. Sam and I need you." Later, I found out that you had run. I know that you should have accepted the consequences in that moment. What happened with Maddie was a tragic accident that never should have happened. It was preventable. Eleazar, I have forgiven you, and I hope moving forward that you will eventually be able to forgive yourself. I want you to find meaning in Maddie's death and in her honor, and turn your life around. Find a way to speak your truth about the fatal dangers of guns, and don't let something like this happen to other families. Thank you.
Is there anyone else state?
No, Your Honor.
All right, thank you. All right, Mr. Flores, they'll take you into custody. I hope you've internalized what has been said, and hopefully you will make better choices, okay?
Yes,
All
ma'am.
right, good luck to you.
Thank you, Judge.
And we are back on the record on, I believe it will be Mr. Esparza in just a moment. So state on Mr. Esparza, I received an application, but they've circled community supervision. So are we only doing community supervision?
That's correct, Judge.
Okay. Well, I already had the one that has community supervision. I didn't. All right. Mr. Esparza, if you and your attorney can come forward, please. All right, we are back on the record. So where we left on, I read the plea bargain agreement. So is there any changes to the plea bargain agreement that I previously read? State?
No, Judge.
Defense?
No, Judge.
All right, so Mr. Esparza, you do understand that you are not applying for deferred adjudication. Do you understand that?
Yes, ma'am.
All right, so then does everyone agree that that is the plea bargain agreement that the court read? State?
Yes.
Defense?
Yes.
Mr. Esparza?
Yes, ma'am.
All right, next I'm going to show you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation, 100 hours of community service restitution, 10 days in the Bexar County Jail, DWI intervention, DIP live, ignition interlock for half the term, and 2-year Texas driver's license suspension. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest. No contest.
States, any evidence to support the defendant's no contest plea?
Yes, the state offers states Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor.
Mr. Esparza, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily consented to waive, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client?
Yes, Your Honor. I understand there's 10 days as part of the sentence. We asked that that would be either through GPS or weekends because he's gainfully employed. And also, I believe he's been on interlock for the last 6 months. And I don't believe that he's had any back readings. So we'd asked that the court give him credit for the 6 months he's already had the interlock on his vehicle.
Okay. All right. Mr. Esparza, why do you keep drinking and driving?
I've just had that time had stopped for a while, and at that time I lost my nephew, and then I got real depressed and sad for him, and I drank that night, and I was drunk.
Do you imagine how much destruction you could have caused? Because
Yes, ma'am.
according to this, you're cutting off the EMTs, you're driving unsafely, you have alcohol in the car. So what did you learn? Because I'm assuming you've done AA before, right?
AA, is that what you said?
Yes. Have you done AA? Have you done treatment before?
Yes, ma'am.
So what are you supposed to do when you think you're going to take a drink?
Either stay home or not drink.
No, you're supposed to pick up the phone and call your sponsor.
Okay. Well, I haven't had a sponsor in a while, and I didn't have any sponsors at that time.
Well, you need one.
Yes, ma'am.
I mean, it's obvious to me that you're an alcoholic, and people want to say it's a dirty word. But here's the thing. Once you recognize you have a problem, once you say its name, it's not like it's Voldemort. Say the name. And then what you do is you stop doing it. But brushing it on the rug, pretending it doesn't exist, results in you having a DWI, and you could kill somebody if you're drinking and driving.
Yes, ma'am.
I always tell people, you want to drink and you don't want somebody telling you not to drink, drink and stay in your backyard. Go for a walk. What may end up happening is you may end up getting hit and killed, or you could injure somebody because they're trying to dodge you from walking in the street. But from my experience, and I haven't done a statistical analysis of this, but usually what ends up happening, somebody's driving intoxicated. They end up hitting someone. The person they hit ends up dying, and the person who is intoxicated is just fine. And they come to court boohooing and crying, don't want to go to prison, upset that they killed someone. So you're an alcoholic, which means you can never take a drink because you don't know when to stop. You understand?
Yes, ma'am, I do.
I'm not going to give you any credit for the time that you've been on the ignition interlock. I actually think you should be on ignition interlock for the rest of your life, but I can't do it. Not allowed to. So I'm going to do ignition interlock for half the term. $1,000 fine probated, 4 years in the prison, suspended and probated for 3 years, 100 hours of community service restitution. If you get the COVID vaccine, the complete vaccine, 40 hours will be knocked off. I'm not forcing anyone to get it. You don't have to get it if you don't want to get it, but if you do, you'll get credit charged towards your community service hours. Okay. Proof of employment within 30 days, no employment as a home health care provider with minors, DWI intervention, DIP live, 2-year license suspension, well, 2-year driver's license suspension, $10 days in the Bexar County Jail, and I will do 30 days GPS partial. Defendant is allowed to work in lieu of the 10 days in the Bexar County Jail, and the court is doing that because of the pandemic. There's to be regular reporting by Zoom or in person if there's a problem with your Zoom to probation. Random field visits 1 time per month. And are you going to test positive for any type of drugs, Mr. Esparza?
No, ma'am. No,
And
ma'am.
we'll do regular drug testing. Rebecca, is there anything else that Mr. Esparza needs?
No, ma'am.
And I'm sorry, I'm going to do a referral of felony drug court. Mr. Esparza, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And Mr. Esparza, you might want to remove any type of alcoholic beverages out of your house. Please do not come back to me for a violation report and saying that you're drinking mouthwash or something else that has alcohol in it. Do you understand?
Yes, ma'am.
So from here on out, you better read the ingredients on everything that you're drinking, because I'm not going to be very accepting of you saying that you drank NyQuil. You understand?
Yes, ma'am.
And I'm referring you to felony drug court, not as a punishment, but I think you really desperately need some treatment, okay?
Yes, ma'am.
If there's nothing else, I'm going to send you to the breakout room with probation, and probation will go over conditions with you. So I'm going to send you to breakout room number 1. And then who is the person who's coming for John Closner? And then we'll take up Mr. Pouch.
I think that was Corley, Judge.
I'm sorry, who was that?
Linda Corley.
All right, can you call her and see what's happening with Mr. Mr. Closner?
Yes, ma'am.
I'm here, Your Honor. I'm just waiting for the attorney, ma'am.
All right, I've seen you, Mr. Closner.
Yes, ma'am. Sorry, I didn't mean to interrupt you.
Oh, no problem. I figure I would take this case up while we wait for the deputies to finish with Mr. Esparza in the breakout room. All right, if everyone will just give me 5 minutes, please. Frank? We'll get to your case shortly. I'm just waiting in the courtroom because
Mr. Morgan,
the probation officer, she is
Yes,
actually, the probation officer is actually Zooming in the courtroom. So I want to make sure that we're silent in the courtroom once we start. So as soon as she finishes Zooming, going over conditions with the last case, I'll take your case up.
thank you, Your Honor.
All right, thank you so much for your patience. Okay, are the parties ready on Mr. Pouch? Who's the prosecutor on Aaron Pouch case, please? It's assault, family choking.
All right, Judge.
All right, we are back on sentencing on this case. There were some concerns the court had with the PSI report. And so I'm going to call the case because Brett, I know I didn't call it. The court is calling 2020 CR 0160 State of Texas versus Aaron Pouch. That parties announced for the record for the state.
Ray Garcia.
For the defense.
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Pouch, who is live and present in the courtroom.
All right, we're proceeding by video. Is there any objection from the state or the defense?
None from the state.
On behalf of Mr. Pouch, no objection, Your Honor.
All right, it's the court's understanding that the probation officer sent everyone an updated PSI report. Have both parties had a chance to review that report? State?
Your Honor, I don't see one in my inbox.
Okay, I'm sorry. I sent it to David. I saw his name on it. I'll forward it to you.
Thank you.
And Mr. Sandoval, have you had a chance to review or see the updated PSI report?
I have, Your Honor.
And then we will give the state a chance to see that.
I just sent it, Joy.
Thank you. I received it, Judge.
All right, thank you. All right, let me know when both parties are ready to proceed.
And I believe it was just for the Louisiana criminal
Yes.
history. Okay, I'm ready to proceed, Your Honor.
All right, and State, you are silent on the application. Does the updated PSI report change your decision to remain silent?
No, Your Honor.
All right, and is the complainant aware of the offer that was tendered and made to Mr. Pouch?
Let me pull up the notes, but I believe so. Yes, Your Honor, we have been in contact with the complainant.
All right, to probation, it says here that the complainant will provide a victim impact letter.
I sent that in the initial email. Do you want me to resend that?
No, the court has it. State and defense, have you reviewed the letter?
The state has.
Defense, have you reviewed that letter?
Yes, Your Honor. And just to confirm, there has not been any subsequent statements by the complainant other than this letter, because that was the only question I had with the updated PSIs. Because yes, we have received the initial one that was initially present at the first attempt at sentencing.
Okay. All right, then defense, the state is silent. Anything you wish to say on behalf of your client, or do you have any further witnesses for the court to hear from?
Your Honor, good afternoon, and thank you again for the opportunity to appear before this honorable court. Judge, for a housekeeping measure, does the court, would the court like any refreshment as to the testimony from Mr. Pouch's roommate regarding the support and that he would receive should this court in its ultimate wisdom grant community supervision, or Mr. Pouch's history with respect to the living environment that he's presently living under?
All right, the court recalls the testimony that was given prior to today.
Thank you, Your Honor. Your Honor, with respect to the Louisiana matters, which the court rightfully sought clarification on, I believe that corresponds, and Mr. Pouch is available for any clarification or explanation necessary with respect to the his history out of Louisiana. In short, he was placed on, he was confined, then placed on parole, and the parole was moved over here to Texas. which where it ultimately was completed. Your Honor, Mr. Pouch, as the court is aware, and no offense because he and I are nearly the same age, this is not his first rodeo, and he appears before you admitting that, and that history is one that he is not proud of, but that he brings along in front of you willingly and without any sort of justification. We merely ask the court, in viewing that history, to put it in its proper context. That history is 10, 15, 20, 30 years of history. If you look specifically at Mr. Pouch's recent history, Your Honor, he is on probation and successfully being supervised out of Kerrville. That supervision, while he's been on bond on this case, has included drug testing, has included reporting, has included monies necessary to be paid. And that history, Judge, is what we would respectfully ask this court to place a great weight on, because if history is any indication of future success, he's been successful at this probation. He's been successful in his attempts to turn his life around. He cannot deny or avoid the history prior to that. This was, as the court mentioned in earlier proceedings with other individuals, a tumultuous relationship where Mr. Pouch appears before you taking full responsibility for his actions in the totality of the circumstances of this relationship. And he's put this relationship behind him, as the court so often asks of other individuals who appear before this court. There have been no violations with respect to harmful or injurious or direct contact with the complainant. Mr. Pouch removed himself from Bexar County with the court's permission and is living an hour and a half away and doing very well in his chosen profession, which is auto mechanics. Your Honor, given the totality of Mr. Pouch's history, especially with respect to his recent success in adhering to the terms and conditions of his current community supervision, we respectfully request this court to allow him the opportunity on his path of turning his life around.
Oh, Mr. Sandoval? Mr. Sandoval, I'm sorry, you went out. After you said that.
Okay, am I back now, Judge, or?
Yes, you're back now.
He would like the opportunity to continue proving himself, not just to you, Judge Boyd, or to his current probation, but also to himself. The history is not who he is now and not who he wants to be. With all the authority that this court has over him, he appreciates and understands that any misstep, even inadvertent, would prove greatly with respect to the consequences. The opportunity is what he's seeking, Judge, to continue what he's been doing so far in most recent history in gathering his life and moving forward.
All right, anything else you wish to say, Mr. Pouch?
You know, I'm 53 years old and I made plenty of mistakes.
Just 1 second, let me have you raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, yes, ma'am.
All right, you can lower your hand. Yes, you may proceed.
So, you know, I made a bunch of bad mistakes. You know, I had kind of a rough childhood,
Not mistakes, you made choices.
I made choices, yes, ma'am. And I take full responsibility for them because I did them. But you know, I'm 53 years old now. And when I got out of jail last time, I'd spent 18 months in there and did a lot of thinking and forgave a lot of people and let go of a lot of things. And I just figured, you know, you're either going to get it right this time or you're just not going to get it right. I'm 53. I'm not getting any younger. As it stands today, these are the same clothes that I wore last time I was here because I don't have any good clothes that I go out in because I don't go out. I go to work and go home, and I do a great service for the community. There's a lot of people that they're happy with my work and my business is flourishing. It's a lot better on this side than having to look over my shoulder or be in a bad relationship. I don't even have a girlfriend. Don't care to have one because I have to focus on myself before I can do anything good for anybody else outside of my job. So the things I did, I take full responsibility for. I'm sorry. I apologize. But I'm changing that and I'm working on me and only me. I don't have time to help anybody else outside my job. I work 40 to 60 hours a week. And I love my job and I'm happy right where I'm at right now. My probation officer says I have to come in. I come in. He said, if that color, my color comes up and I have to go take the UA, I go take it and I pass. I haven't had any problems and I pay my fees and I'm just trying to toe the line and do exactly what I'm supposed to do and not just act like an immature kid or make stupid choices. I apologize for everything that I've done in the past.
All right, so here's the thing. The state is silent on your application. I'm going to give you a choice. You can go to prison for 3 years. You'll be done. You probably won't spend the entire 3 years there. Or you can be on probation for 8 years. And if you don't successfully complete that probation, you could end up going to prison for longer than 3 years.
I understand. As it stands, you know, I lost everything this when I went to jail, everything. And when I got out, I built myself up from my socks up, literally.
Well, Mr. Pouch, those are your two choices.
Yes, ma'am. And so, well,
you can either go to prison for 3 years, or I can place you on 8 years probation.
Okay, I'll take.
If you're not successful at that probation, there's a chance you may end up going to prison for longer than 3 years. You know yourself better than I do. You know yourself better than your defense attorney does. And when I say you know yourself, this is the thing. People need to look at themselves honestly. As my grandmother would always say, you want to lie to other people, lie to other people. But whatever you do, don't lie to yourself. So be true to yourself.
I'll take the 8 years, ma'am.
All right. As previously stated, I found there was sufficient evidence to find you guilty. I'm finding you guilty. I'm going to sentence you to 6 years in the prison, suspended and probated for 8. There's an affirmative finding of family violence, the BIPP course, $100 to an approved family violence center, no contact with Tony Turner. Are you living here in Bexar County or no?
No, ma'am. I moved out. I moved as far away as
Which county?
I live in Kerr County. Kerrville, Texas.
Referred to Kerr County. He's to report by Zoom or in person 2 times per month until further notice. If you're drug tested today, what are the results going to be?
Negative, ma'am.
All right, we'll do regular UAs. Proof of employment within 30 days. No employment as a home health care provider or with minor children. $130 hours community service restitution. 40 of that will be waived if you obtain the COVID vaccine. I'm not forcing anybody to get the COVID vaccine. You don't have to get the COVID vaccine if you don't want to. However, if you obtain the COVID vaccine and complete whatever dosage it is, be it 2-shot, 1-shot, then the court will deduct 40 hours of your community service restitution. Rebecca, is there anything else? Just one last thing. I'm going to do random field visits 2 times per month until further notice. Rebecca, is there anything else he needs?
No, ma'am.
Mr. Pouch, is there anything else you need from the court in order to be successful in this probation?
No, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction and because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll go off the record. Mr. Pouch, you had better do well on this probation. Do you understand?
Yes, ma'am.
If anything goes wrong while you're on this probation, a motion to revoke will be filed. I will receive it. If it's in proper format, I will sign it. A warrant will be issued for your arrest. You will be picked up wherever you may be, at your work, at home, at a birthday party, wherever it may be. And you will be brought to the Bexar County Jail. If you're unable to make bond, we'll hear your case while you're at the Bexar County Jail. Do you understand?
Yes, ma'am.
And while you're on probation, there is definitely to be no drinking while on probation. You understand?
Yes, ma'am.
And don't get in a relationship. If you want to get in a relationship with an orchid. They're $12. Go buy it. If it lives for a year and blooms, then you may just be ready for a relationship. But right now, you're not ready for one. You understand?
I understand.
And whatever it is that happened in your past that make you want to hurt people, you had better find out what that reason is and talk to somebody, talk to a therapist if you need to talk to a therapist. You understand?
Yes, ma'am.
And if you need one, probation will make sure you have one.
Yes, ma'am.
I'm going to send you to breakout room number, courtroom, if you could go to number 1, please.
Yes, ma'am.
And Mr. Sandoval, thank you for your patience. I'll send you to breakout room number 1 with your client, and then you are excused. Linda Corley, I thought I saw her zoom in here.
Judge, are you ready for me to go to 1?
Yes, you can go to 1.
Okay.
I think they're working on paperwork on Linda Corley's case.
I'll be right back, Judge.
Sure, no problem. Everyone, we will go on a short break. All right, Mr. Sandoval, if you don't have anyone else with us, then you're excused. Oh, you're muted.
Thank you, Your Honor. I appreciate it.
Oh, no, thank you for your patience. Have a great rest of your day and a great rest of the week.
Thank you, Judge.
Bye-bye. All right, so everyone, the last person we're waiting on is Linda Corley, and they are in a breakout room. And I don't know if they have paperwork or not.
They're going over paperwork, Judge.
All right, Normie, can you, does Rebecca need to remain then? Is it something where we're gonna?
Yes.
All right.
This is Linda Corley for John Closner. We have returned and we are ready for him to be sworn to do the plea.
All right. I will send you and him to a breakout room, and the clerks will swear him in. And so I'll send you out to breakout room number 1. And just so everyone knows, none of the plea paperwork has come my way. So clerks, I hope you have it on your end.
Judge, I have not received the paperwork yet.
Well, if you will go to that breakout room, please, breakout room number 2.
Yes, ma'am.
Thank you.
That paperwork sitting in Mr. Klosner's email waiting to be signed.
Okay, thank you. All right, it's my understanding that all the paperwork is in, so once they are sworn in, we will take up Mr. Cessna or Mr. Closner. Brenda, we've had so many people today. Brenda, this is the last one for today. All right, our party's ready. Who's the prosecutor? Mr. Closner.
I believe David Martin,
Okay.
but I may have
Joe
worked. I
Ray's
can't
here.
remember.
All
Okay,
right.
great.
Court is calling 2021 CR 5795, State of Texas versus John Leal Closner. Can I have parties announced for the record for the state,
Joe Ray Garcia.
for the defense?
Linda Corley.
Are you Mr. Closner?
Yes, I am, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Mr. Closner, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision or Deferred Adjudication. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, I did.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor, I received everything that I'm aware of, and I did review it with my client.
Court will find that the state is in compliance with discovery. Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you're proceeding on count 1 and abandoning count 2. Is that correct?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
To close, and I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did.
You're charged with assault of a pregnant person. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
We have discussed his defense thoroughly, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I've seen no evidence to say not, Judge, so I believe he is.
Mr. Closner, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, I am, Your Honor.
Are you a U.S. citizen?
Yes, I am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 1, waiving and abandoning count 2, recommending deferred adjudication. There's an affirmative finding of family violence in the BIPP course. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of the agreement? Sorry?
Yes, ma'am.
Defense, is that the agreement?
It is, Your Honor, and we would like to talk to you about the no contact order, Judge, and the classes.
All right. State, is that the agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be for 5 years, a TAP evaluation, no contact with Carissa, Karissa, Wilburn, Wilburn, parenting classes, $100 to an approved family violence center. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
It offers State's Exhibit 1 and all its attachments.
Any objections?
No objections, Your Honor.
Mr. Closner, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes.
Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. How the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client has been on bond for quite a while, and he has also been working with CPS. They were involved in this case. We want to let the court know that he has done a one class that's a 13-week class, and Your Honor, that was called. I'm sorry, let me find that real quick. I had it up. It's a San Antonio fatherhood class, Judge. We have a certificate that he can provide to his probation officer. He's in the middle of another program that he thinks is another 13-week parenting program. In addition, they have been working with CPS, cooperating and following, doing all the services to try to work towards reunification. I do not believe the mom has custody at this time. I believe another family member does, but they are currently working towards that. To that end, Your Honor, we would like to request if you would allow them to have, instead of a no contact order, a no harmful or injurious contact order with Carissa and the child, so that they continue these services. They have been working for quite a while, and I have spoken with Carissa. She does want to be able to have contact with him and try to get the family back together, Judge.
Why is Child Protective Services involved?
Your Honor, when my girlfriend gave birth to our child, obviously we weren't in contact, but her mother called CPS services on her for some God reason because she doesn't want us together. So she got CPS involved and ended up taking our child away because
CPS just doesn't come and take a child because somebody got somebody involved. So what is the underlying?
Took the baby away, our baby away, because I guess Krista got into an argument with one of the CPS workers. So they told her that we're just going to take the kid away. I don't know because the fact that
I don't think John knows the allegations, Judge, specifically because they weren't having contact at that point. I think all he knows is he got contacted by CPS and they started working services, Judge. I think he doesn't know the answer.
Okay, because the explanation he was giving me are not.
I don't know very little.
Explanations.
I just said that at the beginning instead of wasting your time right there. But no, like I said, I the only reason why I'm involved with CPS is because they said that because I'm the father of Kinsey, then I was brought into this. No, originally CPS was called on her, not me.
Okay, thank you, John.
Thank you.
All right, so that's still strange to me that they're having services done. Linda, do you know why services are being done?
I don't know, Judge. I should have probably asked her. I could probably get her to log in. But I do know that her mom does play a major part of this. She's been very vocal, and I think that's indeed why the no contact order was recommended, because the mom doesn't want them to have contact. But they are adults and they do want to get back together, and they have been trying to follow the rules now and do what's needed to be able to have a safe and healthy family.
Okay. All right, Mr. Closner, if you drug tested today, what are the results going to be?
Your Honor, I have done drugs in the past. I'm starting to go clean. I don't know what they will be, but I'm.
Well, let's do it this way. What could it potentially be?
Cocaine, ma'am.
Okay. So I think that's why CPS may be involved in their lives. So, Mr. Closner, do you know whether or not your child was born positive for drugs?
Oh, no, ma'am. I done a drug test with CPS. I'm just waiting for
No.
Oh,
I'm not talking about you. I'm talking about when your child was born. Was your child born positive for any type of drugs?
No, ma'am. No, she wasn't. I don't do it like frequently. It just, yeah.
Thank you, John.
Okay. When's the last time you used?
But maybe a month ago. Maybe, yeah, about a month ago. Give or take. A month ago.
So you shouldn't be positive for anything today. That's what you're telling me. Because if you used cocaine a month ago, your test will come out clean for cocaine.
Oh, I don't know. I don't know how long it lasts, but I mean, a month ago.
But I'm telling you, if you use cocaine 1 month from today.
Okay. Yes.
So, okay. This is what the court's going to do. 5 years deferred adjudication, affirmative finding of family violence, the BIPP course, and Ms. Corley, that course is going to have to be done because that's what's legislated. Parenting classes, if he provides documentation that he has completed a course that's comparable to the compadre parenting classes, that will be acceptable. $100 to an approved family violence center. Are you employed, Mr. Closner?
Yes, I am, ma'am.
What do you do?
I am a forklift operator.
All right, proof of employment within 15 days. There's to be no employment as a home health care provider or any employment involving minors. I'm going to want him to do the UA hotline, or either he can do a patch. I'm going to want a drug test tomorrow by 9 a.m. There's to be regular Zoom reporting or in person. If there's something wrong with your Zoom, you're going to have to report in person. There's to be no contact with Carissa Wilburn, and that's for now. I need to see how you're going to do while you're on probation. Ms. Corley, let's see where we are in 3 months. And if things are well, then I will allow him maybe to have contact. Rebecca, is there anything that I'm missing? Excuse me. Community service hours. 120 hours community service restitution. 40 hours will be waived if you complete the COVID vaccine. I'm not forcing anyone to get the COVID vaccine. If you don't want to get it, you don't have to. But if you've already received the vaccination, then if you turn that in, that will count towards 40 hours of your community service restitution. Rebecca, is there anything else he needs?
Did you say CPS compliance if applicable?
Thank you. CPS compliance if applicable. And I'm going to want random field visits 2 times per month. Anything else, Rebecca?
No, ma'am.
Mr. Closner, do you need anything else from this court in order to be successful?
No, I do not, Your Honor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Closner, here's the speech for you. 1, anytime you're in a relationship with someone and you think they may be cheating on you or being unfaithful, guess what? Maybe it's time to get out of that relationship. If you think that it's okay to hit someone else, maybe it's time for you to get out of that relationship. You're supposed to love the partner you're with, and especially if they're carrying your child, because they're very vulnerable at that time. You're not supposed to put your hands on them in anger. Do you understand?
Yes, I do, Your Honor.
And if you're going to be the father of a child that a child will look up to, a father that a child will look up to, you can't be using drugs, because then you're teaching that child that it's okay to use drugs.
Yes, Your Honor.
If you abuse that child's mother, you're teaching that child that the way you show you love somebody is you abuse them. I don't know if you have a daughter or son, but let me tell you something. If you have a son and that's what they see, they're going to think that's how you show somebody love, on top of the fact that it's very traumatic for them when they see that. If you have a daughter and she sees this, she's going to think that the partner she's with, if that partner hits her, that's how you show love. So I hope that you don't want any of your children to think that's okay. And you better start changing your ways. And from here on out, everything you do while you're on this deferred adjudication, you need to ask yourself one question. Is the decision I'm about to make, could that potentially result in me going to prison for 10 years? You understand?
Yes, Your Honor.
All right, I'm going to send you to a breakout room. Probation will go over conditions with you. And if you want that no contact order for me to consider lifting it, you had better be spotless on this probation. You understand?
You got it, Your Honor.
All right, I'm going to send you to breakout room number 2, and probation will meet you in 2. And Ms. Corley, you can go to number 2, and then after that, you can be excused.
Okay, thank you, Judge. Just for clarification on the random field visits twice monthly, will that be for the entirety of the probation, or will you be reassessing that at some point?
I'll be reassessing that at some point. And usually what ends up happening on that is probation will send me notice that the person is doing very well and ask if I will lift it, or at the very least do less field visits.
Okay, thank you, Judge.
All right, you're welcome.
You have a great day.
All right, thank you, you too. All right, everyone. I'm Mr. Closner, you need to go to the breakout room.
Yes, ma'am. I haven't. Oh, here we go. Sorry. That was, yeah.
Number 2. All right, everyone. I'm going to stop live stream because, thank you, Rebecca. I'm going to stop live stream because we're done with our cases today. But we're going to start tomorrow at 9 a.m. And I'm going to talk to Miss Cassandra Montemayor once we stop the live stream. So everyone, thank you so much for your hard work. Have a great rest of your day. And David Barton, I don't know if you're calling from outer space or where you are, but you're in a room with a lot of computers.